The Honorable Court of Appeals for the 7th District of Texas is now in session.
Thank you. Please be seated. Ms. Silverman, can I impose on you to close that door? Please. Are we rolling? Thank you very much. We welcome you to our last oral argument I guess the 10th day of the first month of 2024. It's our first round of oral arguments, and we appreciate your willingness to be the last one today. Though you're last, by no means are you least. We'll go on and call the docket, and just please give us your announcements as to whether or not you're ready. And again, assuming you're here, you are ready, but ask for that anyway. We did notify you the amount of time each side gets, 20, 20, and 5. So the appellants don't have to ask for reserving time for closing because they get the 5 minutes anyway. So with that said, let's go on and call the docket 07-23-00195-CV Sunday Canyon Property Owners Association Inc. versus Kathy Brorman. And if I'm misspelling that or mispronouncing that, please correct me. Creekwood Real Estate LLC, Alyssa Heck and David Wiggins. And again, if I mispronounced that, please correct me. And for the appellant.
Your Honor, Cassie Dallas from Thompson Co. for the Appellant Sunday Canyon Property Owners Association. We are ready.
Okay, thank you very much. And for the appellees.
Your Honor, Matt Sherwood with Carnware and Sherwood Firm, and on behalf of all the appellees, and I'm ready.
Very good, thank you. You have water. You have water. If you run out, there's some water there. So please help yourself. Ms. Dallas, you have the floor.
May it please the Court. Counsel. In June of 2019, 62% of the owners of lots in Sunday Canyon subdivision voted to amend their restrictive covenants, and within that amended restrictive covenant scheme, they included a limitation on short-term rentals, specifying a minimum lease duration of at least 30 days in some instances, and requiring leases of at least 6 months for the lease of a lot to a new tenant. The trial court invalidated, through a summary declaratory judgment, invalidated the restrictive covenants.
Where did the trial court do that?
The trial court summary judgment order at Court Record 591.
What does that order say?
That order says that the summary judgment on the declaratory judgment claims is granted.
What else did it say?
That's it.
What's the effect of that?
Well, Your Honor, that leads me to my first point that I want to talk to you about today, which is that the declaratory judgment in this case, which was incorporated into the final judgment, does not allow the parties to discern what the court declared from the face of the judgment or from the pleadings.
Let's assume, arguendo, that partial summary judgment was actually a final summary judgment. Would it have been final?
Your Honor,
simply stating the motion is granted.
Your Honor, the time that the declaratory judgment, summary declaratory judgment was granted, there was a supplemental breach of contract claim.
Let's assume, let's just focus on the declaratory. Let's assume, arguendo, that the only claims brought were declaratory. Let's forget about the promissory estoppel, takings, and all that other stuff. Breach of contract. If the court enters a summary judgment that says it is granted, the motion is granted, is that final? Assuming there's no other claims.
If there are no other claims and the summary judgment disposes of all claims and all parties, then an order granting summary judgment is a final judgment.
If it just says the motion is granted.
Your Honor, my understanding of the Lehman Brothers case would be that that is a
Are
final
you
judgment.
familiar with our decisions in Reader, Christian versus Reader, or Disco, Liberal, Kansas, that basically say in that situation it wouldn't be following because there's no decretal language.
Your Honor, I'm not specifically familiar with those, but I do think that this court's precedent, as we pointed out in our brief, in particular the Petro Pro case, certainly indicate that a declaratory judgment like this one that does not declare the rights of the parties and does not terminate the uncertainty or the controversy giving rise to the declaratory judgment claim is invalid on its face and requires reversal.
Okay. Are you familiar with the Supreme Court's case in Naaman versus Grider, where it said an order simply granting a motion for judgment adjudicates nothing?
Well, Your Honor, I would hope that this court, I'm not specifically.
Let's assume that's what the case says. So were the declaratory actions adjudicated?
The court entered an order, we objected to the nature of the order, and then the court incorporated that order into a final judgment.
But what did it incorporate? Did it incorporate any language from a partial summary judgment order declaring or decreeing the rights of anything?
Well, Your Honor, no, and that's part of the reason, that's one of the main reasons we're here
Would the
today.
naming decision apply here? That as an order that just grants a motion, says the motion is granted, adjudicates nothing? Were the declaratory actions adjudicated?
Your Honor, to the extent that the court ultimately entered a final judgment on them, I think that they were, but the problem is.
What language in the final judgment would indicate they were adjudicated?
That the court intended to incorporate her ruling on the declaratory judgment claims and then
What
resolve.
incorporates an order that, under by law, as a matter of law, adjudicates nothing? What does that final judgment adjudicate?
If under law it adjudicates nothing, what does it adjudicate? Well, Your Honor, I
It's
think.
not a trick question.
It sounds a bit like a trick question, Your Honor, but I would say that, part of the reason we're here today is that we raised this issue multiple times with the trial court, that there were substantive issues with her declaratory judgment claim, or just declaratory judgment order, simply granting the relief requested, and the trial court rejected at every turn our offers to specify on which grounds she was granting the declaratory judgment claim and why.
Would you agree or disagree that nothing in the final judgment expressly addresses the declarations that the opposing parties saw, the plaintiff saw?
There is, other than it saying that the plaintiff's summary judgment and the grounds on which plaintiff moved for summary judgment, you can look to the motion and you can tell that those are the 9 declaratory judgment grounds, that those were granted.
Okay,
Other than that,
nothing else?
other than that, no, Your Honor.
If the naming decision were to apply and say that summary judgment, partial summary judgment order adjudicates nothing, the court incorporates an order into its final judgment that adjudicates nothing, and then the court ends its final judgment with the statement, all relief not expressly granted is denied. Is there an adjudication of the declaratory relief requests?
Your Honor, I don't know that I'm going to get to a satisfactory answer for you on that. It may be something that we need to do some supplemental briefing on. But we had a final judgment that the Property Owners Association was required to timely appeal from. And
I understand. I understand it's fine. But what did it adjudicate?
And
Did the final judgment effectively deny the declaratory relief by that last sentence that says, all relief not expressly granted in this judgment is denied?
I don't think so, Your Honor, although I understand the technicality that the court is pointing out. I don't think so, because for all intents and purposes, this record demonstrates that the trial court intended to grant the declaratory relief sought by
What can
the
it
Well,
do?
plaintiffs in this
what
case.
relief was ultimately granted?
Well-
Declaratory relief. So we have to go back to what was pled?
Well, Your Honor, again, I think that's a great question, and I think that this court's decisions in the Petro Pro case cited in our brief, as well as the 56933 Inc. case cited in our brief, clearly indicate that attempting to grant declaratory relief in the way that the court did would be a reversible error. But let's go on to
Why is it reversible error? Because it didn't enter declaratory relief?
because it doesn't resolve any controversy and it doesn't provide any clarity to the parties.
That's what I'm
So,
saying. It resolved no controversy, but if you have in a final judgment, a last sentence that says, any relief not granted expressly in this judgment is denied, why can't we say they denied the declaratory relief?
Your Honor, if that's the route the court wants to go, I think that
I'm asking you, counsel.
I think that ultimately works to my benefit, but I don't know that that's what the court intended. And so I think that's why I
The
think.
court can intend anything, but intentions don't matter until it effectuates its intention in a ruling. That's enforceable, correct?
I think that is accurate, Your Honor, and to the extent that this line of cases was not adequately addressed in our brief, I'm happy to provide some supplemental briefing on it. To Justice Parker's question about what relief was declared, we have operated under the belief that the court intended to grant each of the 9 grounds raised in the summary judgment motion, intended to grant declaratory relief on each of those, and that is why our brief addresses each of the 9 declarations. With lots of minutia with respect to each one, but I kind of want to parse them into 2 different buckets. We have the bucket of declarations that speak to the enforceability of short-term rental restrictions generally. So this is the appellant, Appellee and plaintiff's challenge that they're somehow not allowed under any amendment scheme to amend and restrict short-term leasing. There is the argument that they make that this is in violation of the restatement a third of property servitudes, or that it somehow constitutes a regulatory taking. Then there's the other bucket that I kind of characterize as technical violations of the rules here that make these particular restrictions unenforceable. So these are the complaints about the notary, signature, voting procedures, and of that nature.
Are you suggesting we have to consider each of the 9 declaratory aspects of declaratory relief and reject each of the 9 when nothing in the record indicates which, if any, the trial court relied on?
Your Honor,
intended to grant.
I believe that the court can reverse this case on the first issue raised in our brief, which was that the declaratory judgment claim did not adequately declare relief. I think you could stop there, but I do think that the court should go further and direct the trial court, because there are a number of non-viable legal theories on which the plaintiff sought declaratory relief, and to go back and just be faced with the court entering a similar or maybe a doctored up declaratory judgment on non-viable grounds doesn't help us at this point. I think really what we need some clarification from this court about what makes a short-term rental restriction enforceable. So, with that, there are a number of relatively recent cases that grow out of the Texas Supreme Court decisions in Tar and in J. Bryce Holdings. Those are the 2 cases cited in our brief, Dagon, Adlong, Angelwild, and then more recently the Cawthorpe case out of the First Court of Appeals, which came out in time for us to include it in our reply brief. These intermediate Court of Appeals decisions are all based on a relatively similar fact pattern. In each case, the Homeowners Association or Property Owners Association followed the amendment process in their respective restrictive covenants and established a minimum duration of leases to limit short-term rentals in their neighborhoods. The cases and the reasoning and rationale for enforcing those decisions build on comments from the Texas Supreme Court in both the Tar case and the J. Bryce case, in which the court says, at least with respect to Tar, we're not going to find that merely the residential use provision addresses short-term rentals. But property owners associations, you have the option of going back and amending your deed restrictions in accordance with what the covenants spell out for the process for doing that. The court said the same thing again in J. Bryce in 2022, indicating a clear preference that if a property owners association or a group of neighbors want to restrict short-term leasing, that they look to their restrictive covenants, determine whether there is an availability to amend those, and then follow the process for doing that.
Some of the allegations with regard to declaratory relief or request for declaratory relief pertain to whether or not the homeowners association comported with the procedures used in order to accurately comport with the procedures used to accurately amend, correct?
Yes, Your Honor.
How do we know that the trial court wasn't relying on those?
Well,
Or we're going to have to consider those two, as well as whether or not HOA can amend to limit the RBOs, et cetera.
Your Honor, this record, on this record, and it was the plaintiff, Appellee's burden of proof to conclusively establish that the procedures were not followed. The record establishes that, again, that 62%, 80 of the 129 lot owners, 62% owners of 80 of the 129 lots voted to approve, signed written consents to approve the amended restrictions. The method and process for amending the covenants comes from the original restrictions, which are just as there's multiple copies, but 325 to 328. Very simple, pretty short and sweet. It says that all that's required to amend, terminate, modify, waive, alter, change the restricted covenants is the written consent of the owners of 51% of the lots of the tract.
Your 62% figure, does it track with not allowing multiple people who own multiple lots to vote multiple times? Does it track with that?
Your Honor, all of that argument in the plaintiff and appellant's brief is immaterial hearsay. They're conflating bylaws and provisions that don't actually govern how you go about amending the restricted covenants. So, yes, we get there no matter how you slice it, but their argument and the things that they're pointing out as being potential violations are all immaterial because they're talking about voting procedures under the bylaws and voting to change the bylaws or the rules governing the POA. They're not about how you amend the restricted covenants is in the original restrictions. This court in the Annette case approved that process, and it does not change throughout any of the modifications, and the bylaws don't govern how you go about amending the restricted covenants. So the way that you tally the votes is you look to what percentage of lot owners, what percentage of owners of which lots approved. So we have 129 lots, you have 80 lots essentially voting to approve. That's well over the 51% threshold.
Counsel, your time's running up, so let me ask you some other questions. Aside from the declaratory relief, one of the issues was damages. One of the contentions is you can get damages under the Declaratory Judgment Act. Would you first have to, I know the contention is, no, you can't do it. It doesn't allow for that. But the way the statute is read, would you first have to get favorable relief under the Declaratory Judgment Act before you can recover damages? Let's say you have a breach of contract, part of that is declaratory judgment act. Breach of contract, you can get damages, okay? So I can see where a declaratory action involving breach of contract, you can award damages. But would you have to first recover favorably on the breach of contract or the declaratory judgment aspect of the breach of contract before you can recover damages? Or does the court have authority to say, well, it's a declaratory action, like you can do with attorney's fees, we'll give you damages even if you lose?
Your Honor, I would have to go back and supplement my briefing and find some authority on this, but it's my understanding that you would need to prevail
Okay.
you need to be considered to be prevailing to be,
On the breach of contract?
no,
Under
prevail
declar-
under the declaratory judgment act. I think they're separate
There was also,
vehicles for recovering damages.
aside from declaratory, there was a breach of contract, promissory estoppel.
Yes.
Was taking part of the declaratory or was taking part of the trial?
Your Honor, there was not a separate takings claim. It was a request for declaratory relief that the amendments affected a taking.
Okay. Would promissory estoppel and the breach of contract claims, their viability, their validity, be dependent on securing favorable declaratory relief? Was the breach of contract in that you breached the contract because I could rent when I bought, you changed it, somehow that breached the contract that I could rent?
Yeah, Your Honor, this court's case law says that there's not in a very recent case of this court, I don't have it handy to give you the name, but it is in our brief, that enforcing or not enforcing restrictive covenants does not give rise to a breach of contract claim at all.
Was the breach of contract claim based on anything else other than the restrictive covenants?
No, Your Honor, it was not.
About promissory estoppel, was it based on anything other than I bought this property thinking I could rent it and found that I couldn't, so I should get my damages, or is there another theory underlying the promissory estoppel in your view?
The only theory underlying promissory estoppel was the notion that prior to the amendments they could, and people told them that that the amendments at the time did not restrict short-term leasing, and then the amendments happened and now short-term leasing, there are short-term leasing restrictions. So the promissory estoppel argument, again, we've cited in our briefing, but is a defensive matter in this court, not one that gives rise to
Other courts
damages.
disagree.
Well, Your Honor, this case is in this court, so I think you get to follow your own precedent here. And, obviously there's a lot of issues in this case, not enough time to discuss all of them. And so I for the reasons we discussed and then for the reasons addressed in our briefing, in my final seconds, ask that you reverse and remand this case to the trial court. Thank you.
Thank you, counsel.
May it please the court, counsel.
Counsel, when I first came on the bench, I used to have hair. Since then, I've encountered a lot of issues that, for one reason or not, may be attributed to the loss of hair. I'm finding this is, the procedural aspects of this one kind of borders on that. Was the declaratory relief granted or was it denied via the final judgment?
And that's a great question, Justice Quinn. And I have grown my hair out somewhat longer to hide some of the loss
But
of
I'm
hair
jealous.
that exists here. Yeah. I would blame my kids more than I would blame procedural issues. I admit to the court that the orders that were entered as a part of the clerk's record are not the clearest that I've seen. And I think that what the intent was, when a summary judgment is requested on multiple grounds, and it is ordered granted, we get into a bit of a fight sometimes with the trial court as to how broad or how narrow the order should read, so that when it goes up on appeal, it determines how much is being appealed and what the appellate court looks at. So the order granting the summary judgment clearly, or just plainly says, the request and the motion for summary judgment is granted. And so from Appellee's perspective, the request for relief in the summary judgment is that the ban on short-term rentals be held invalid and unenforceable.
What do we do with the Supreme Court's decision, this Naaman v. Grider, it's 126 Southwest 3rd, 73. It involved a motion for judgment, but since then, other courts have followed it and applied it to summary judgment and say an order just saying the motion is granted doesn't adjudicate anything. What do we do with that, since that's all the order says here?
I think that because of how specific the motion was granted and the specific relief that was requested, tying those two things together can give us our answer as to what the trial court intended in granting summary judgment. The trial court, by its order, intended to grant the summary judgment in its entirety.
Do you agree or disagree that the trial court can intend to do something, but for some reason it never does it? Can we enforce a trial court's intent to do something if the trial court never effectuates that intent through an enforceable order?
I think that if the trial court specifies its intent through its written order, you can.
Well, how do we know that the trial court intended to grant a partial summary judgment on all the requests? Because it's just, the order says, and the summary judgment evidence has been for consideration, the court determined plaintiffs are entitled to summary judgment. Didn't say based on all.
Or any?
It simply says that therefore order that the motion is hereby granted. And to me, that granting of the motion grants it on all of its grounds. I think that's the only way that it can be interpreted.
As I indicated, as I discussed with opposing counsel, if those were the only claims involved, not the promissory estoppel, breach of contracts, and the court entered a summary judgment that basically said summary judgment's granted, we wouldn't have a jurisdiction under our cases of, Christian versus Reader, Disco, all those others, because it lacks decretal language. In other words, the court hasn't adjudicated anything. So it's not final judgment. The court was clear in those cases, the court intended an outcome, intended probably to grant the relief, but it never did because it never granted, specified through the rights of the parties in the adjudication. So even though the court intended, can we say it did adjudicate?
I think you can simply because of the specific pleading of the summary judgment, the specific request for relief in the summary judgment, and that the order grants that. I think that's without having any other specificity, that's the only way that this court can interpret what the trial court did. And since it is not a final judgment in the summary judgment itself, obviously, I'm like Ms. Dallas, I'm unfamiliar with the case of the court is citing, and I would also welcome the chance to offer some briefing on that issue. Again, I fully admit to the court that the order that was signed by the trial court is not as specific as maybe we would certainly like, but I do think it orders that relief be granted in accordance with the motion. And the motion is specific as to what it's requesting, and it specifically requests that the amended restrictions that are in dispute here be held in bounds. And that with the court, by granting that motion, indicates that it believes that those declarations should be entered and that the amended restrictions are valid. If there's anything else on that procedural issue, I think I kind of feel my hair receding as we're talking about it. If there's anything else that the court would like to talk about with that, I'd be happy to answer any other questions, other than happy to launch in a few
Let me
minutes.
ask you this, let's assume that arguendo that Neiman does apply and the court adjudicated nothing in the partial summary judgment. By entering its final judgment in the Mother Hubbard language, all relief not expressly granted, in this judgment is denied. Did the court effectively deny it?
No, Your Honor, and that's an interesting question. I haven't looked at that, the Mother Hubbard language on a case. I think I argued a case in front of this court that had to do with that maybe 10 years or so ago. And I know that the Mother Hubbard language used to be kind of an end-all, be-all. The courts have kind of shifted away from that. But in the final order, because it incorporates the order granting the summary judgment, indicates that the trial court was intending to follow through with its order, granting the declaratory relief requested by the appellees here. So I don't think that it would kind of, I guess, trump something else. I'm trying to think of a good...
The final judgment itself, aside from reference to incorporating partial summary judgment, the final judgment itself does not expressly declare rights.
It does not.
It awards damages and it assigns attorney's fees, but it doesn't clear any rights.
It does not have a specific declaration of rights, that's correct.
Okay.
From time to time, for example, in a criminal case, a final judgment in a criminal case can say, hey, this guy pled guilty, and we have a whole trial and we know he pled not guilty. So we know from the record he pled not guilty, and we're allowed to reform that judgment because of the evidence in the record. Are we allowed to do that in a civil case? If there's evidence in the record that, hey, she intended to grant these 9 things, are we allowed to reform that final judgment?
I think, I don't know the answer to your question off the top of my head, Justice Yarborough. I do not know. I know that obviously there are methods by which the trial court can clarify its rulings. I don't, off the top of my head, I don't know if a non-pro-tunc would be a potential way for the trial court to, I guess, specify or make clearer to the appellate court what it did order.
And then pro tem applies to judicial action versus what, a clerical mistake?
That would be, I guess that would get into whether or not we're modifying the judgment or clarifying a clerical mistake. That's right. I don't know the answer to that question off the top of my head. So to that extent, I know that this court has in other instances, at least in one other instance that I've argued in front of this case, in front of this court on a case out of Crosby County, sent an order back to the trial court to clarify rulings. I think in that case it was a findings of fact and conclusions of law issue. But so that may be a potential available remedy as well. But I do think at the very least, based upon what the orders were that the trial court issued, the trial court declared an intent to grant the summary judgment for declaratory judgment for the appellees. It incorporated that summary judgment order into its final judgment so that the trial court is telling the appellate court, yes, the appellees won the issue of declaratory judgment. It didn't specify what the actual declarations were. So I think that the way to interpret that would be based upon the requested relief of the summary judgment, which was granted in its order.
So we look at every declaratory, every aspect, or every aspect of declaratory relief request to determine whether or not the trial court erred in granting that partial summary judgment.
Yes, Your Honor, I think that would akin that to if I move for a summary judgment on a negligence case on the issue of duty and breach, and the trial court grants summary judgment without specifying which, it's up to the appellant to defeat my summary judgment on both issues, duty and breach.
In that situation, of course, you have an actual adjudication because the court says, yes, I'm denying you recovery or something along that line, which we don't have here.
We certainly don't have it clearly, maybe. As to the meat of this dispute, this court finds itself hearing this case in a time that's where this issue is kind of a hot button issue around the state. As of the time that we're arguing this, the Texas Supreme Court has full briefing on the Fournier versus Angel-Wide HOA case. We've been tracking that case. I don't think that oral argument has been set on that, but the case has been fully briefed on the merits. As Ms. Dallas indicated, there have been 4 other intermediate courts of appeals who have weighed in on this. The Beaumont Court of Appeals first, and then the other 3 just kind of riding its coattails. The major difference in this case as to those other 4 cases from the other intermediate courts of appeals in Texas, in none of those cases was there a dispute about the voting procedure as there was here. And while I understand that the appellant wants to just kind of wash that issue or sweep it under the rug and say we got this many votes and it's all fine and it's all dandy, there are so many procedural hurdles that they failed to overcome to pass this vote that whether or not this court wants to weigh into the issue of whether an HOA should be able to take away a very valuable bundle of sticks from homeowners who don't consent, you can uphold this summary judgment based upon the fact that it is absolutely clear that this property owners association did not follow its own rules, both in the dedicatory instrument and in its own property owners association bylaws to pass this rule. Number one, the idea that this one vote per owner per lot thing is simply a bylaw issue, it's not. The declaratory instrument for this came out in 1964. It says 51% of the owners of lots can vote to amend or delete these restrictions. That was amended in 1983, and then so it created the Property Owners Association. But that amended declaration made an important change, and that's where the language comes in that says you cannot, as an owner of more than one lot, vote more than one time. The language itself says that no matter how many lots an owner may own, the owner may only cast one vote. And to me, that actually makes a whole lot of sense, such that if you have, early on in developments, you have a developer or two that own a vast majority of these lots and kind of wield unruly power over the rest of us. We had that same situation in the development that I live in with my family, where we were supposed to have a park that was supposed to be paid for by these developers, but then new lots were added to the plat. They owned so many lots that they had 51%, and they voted to make it to where they don't have to build their own park. So the rule makes a lot of sense, such that you can't have a handful of people owning several different lots and wielding multiple votes. That's in their own, the amended bylaws, that's in the amended declarations. We know they didn't get enough votes for that. We provided that tally. It's in there's a nice chart for it in the summary judgment. I think it's page 33 of the second supplemental record. We spell out exactly the way that the ownership was supposed to have voted, how many votes they could have counted. They didn't get there. On top of that, the notary issue is a big deal. And it's a big deal legally under the Texas Property Code, because you can't file something without valid notary signatures the way that they did, because it's an interested property. And secondarily to that, the POA's bylaws say that if we're going to have a vote, which to the extent this was even a valid vote to go around on a golf cart grabbing signatures from people over the course of several months, which we don't think it is. But the way that the bylaws for the POA work is whatever the written ballot is, you have to follow. That's what they say. They set the ballot, you have to vote in accordance with the written ballot. And Mr. Downey's brother notarized these ballots that were required by the POA to be notarized, and he wasn't a notary.
So they're in effect, they didn't follow the procedure.
They're ineffective either because there has to be valid notary for it to be filed, or the POA's own bylaws, they set the rules. They said, if you want to vote in favor of this amended restriction, here's the ballot, here's how you have to do it. And then Mr. Downey with his brother goes and gets these votes, and he did it wrong. And so they can't now just say, well, not a big deal, we did good enough. No, follow your own bylaws, follow the rules. And they didn't. And on the list of
another ground for declaratory relief related to takings. How is this a taking in your view?
So we get into where a POA gets to kind of be a quasi-governmental actor. I mean, they're given power and authority both by the declaratory instrument and by the Texas Property Code to use certain governmental powers. In this case, the power to fine owners who don't comply with these alleged rules, the ability to use the court system to enforce these rules, which essentially amount to almost like their own little statutes, municipal code. So they are acting as a governmental actor, even though they're not a governmental entity. And
so is there another element to takings?
The removal of the property right, and under the name of the case escapes me. The Penn Central and the Edwards Aquifer Authority versus Day case.
There's also an element of for public use. What is the for public use?
Here, the POA acting, allegedly acting on behalf of the public in administrative rules and taking away a property right would do that.
On behalf of the public?
Well, its own little confined area of the
Public use connotes that the entire public can benefit from that use. How can people outside that group benefit?
As to, I don't know about the public use element. In my understanding of the law, Justice Quinn, was that if it's a regulatory taking and the acts by the quasi-state actor amount to an interference with investment-backed expectations, that's all that we would have to show for that.
One of the elements is kind of like an inverse condemnation, regulatory taking, inverse condemnation.
It would be similar.
One element is public use
For an inverse condemnation, yes.
and a regulatory taking.
And so, I think the Tiki Island case out of the Houston Court of Appeals in 2015 dove into this issue specifically, and on a case where they were taking groundwater and had to pay for they're not taking it, but they were regulating the use of groundwater, that they found that the groundwater was a valuable asset to the landowners, and that the regulation of that, which prevented the landowners from using the groundwater, amounted to a taking.
And in that case, it was a public use too, because that was furthering the state's interest in conserving water.
And then, I guess what I would argue then is that the Sunny Canyon POA purports to be acting on behalf of the public to protect the members of Sunday Canyon.
There's a state's policy that says we favor or do not favor VRBOs.
The state's policy?
Yes, because the case that you cited, they said there was a public use because it was furthering the state's policy of conservation of water. So they're looking at it is public use because it's furthering something that's good for the state, for the public. Whereas that policy here that the state has with regard to, I say Airbnbs, VRBOs.
Well, what I think the way that it would apply, to the extent that public use applies in this case, that the POAs are available as a means to help regulate and provide, at least and specifically in this case, the safety and welfare of the people that live in the development. And that has been the excuse that's been used, that we're going to restrict your ability to lease your property, requiring you to lease it for a specified period of time for some vague safety reason.
Almost out of time. One more question, at least one more. Promissory estoppel, breach of contract. Are those dependent on the viability of the declaratory action claims? If we said the court erred in granting, assuming arguendo, if the court erred in granting the declaratory relief, do the promissory estoppel, breach of contract remain on some separate basis, or are they dependent on securing declaratory relief?
So the breach of contract action can be separated from the declaratory relief because the manner in which the POA went about and went around its bylaws to cram down this vote in violation of its own bylaws would be a breach of that contract by the board, and would allow for relief under that breach of contract and contract damages. Doesn't necessarily, while I can see how they would potentially go hand in hand.
Isn't that still an aspect of the declaratory relief claim? That they deviated from the procedures? You'd have to find some type of deviation first.
You can't, I think that's one of those where the line between declaratory judgment and a breach of contract is gray. But I think that an independent cause of action for breach of contract exists in this case for that issue, separate and apart from the declaratory relief as to the amended restrictions themselves.
How about promissory estoppel?
Promissory estoppel can exist independent of the declaratory relief as well, because there's evidence in the record, both in the summary judgment record and in the trial itself, where members of the POA board made representations to the appellees that you are able to come here, purchase this property, and lease it short-term, and one of them said, I'm going to do it myself. That's it. Thank you, Mr. Stewart.
A few points on rebuttal, Your Honors. With respect to this question of compliance compliance or non-compliance with the voting procedures and the bylaws versus the restrictive covenants versus any modification of covenants. As the movements for summary judgment on their declaratory judgment claims, it was the plaintiff appellee's burden to conclusively prove some kind of violation. The response and the evidence submitted indicated that the original restrictions, which set out the amendment process for amending the restrictive covenants, were followed and there were sufficient votes. That is even if you consider the first modifications, Article 2, which describes membership and association and voting rights. And counsel gave you the first part of that paragraph correct, but forgot to mention that when multiple owners own multiple lots, then they get the opportunity to decide among them who's going to vote for which lot. So if a married couple owns 2 lots, each of them under the modification can vote for their respective lot with the limitation that there should be no more than 1 vote per lot. So when you go back through and you tally up the percentage of owners of lots who voted in favor of the restrictive covenants, you still end up over 51%, no matter how you slice it. So the evidence before the court conclusively established a sufficient number of votes to pass the restrictive covenants. With respect to the notary issue and all of that, there is nothing in the amendment process in the original deed restrictions that requires notary. All it requires is written consents. So again, you go back to the restrictive covenants, not the bylaws, not a letter from the POA president. You go to the restrictive covenants to determine the method and manner of amending. And the evidence here showed that that method and manner was followed, not that it conclusively was not followed. So they didn't establish their summary judgment burden as a matter of law, and even if the court wanted to entertain the legal argument there's fact issues that would preclude and prevent the declaratory relief that's entered. So, and really that goes back to the main point that I started this whole thing on. Was this a voting problem? Was this a technical compliance problem? Or is there something about short-term rental restrictions that is unenforceable? Well, under existing Texas law right now, the district court is completely contrary to the vast majority of cases that have ruled on this issue. Adlong is a very well-reasoned decision, the Beaumont Court of Appeals decision, that actually cites to this court in Sunday Canyon versus Annette, which was a 1998 decision from this court that dealt with the same original restrictive covenants, the same amendment process, and ultimately affirmed the modification, the first modification and second modification, which allowed for assessments and things like that in Sunday Canyon. The other point that I wanted to raise has to do with the damages. Now, it's our position that we never even get there. That there is not a vehicle for obtaining damages from the Property Owners Association because you don't get there under the Uniform Declaratory Judgment Act. Promissory estoppel is defensive. There is no taking. There can be no taking because Sunday Canyon is not a state actor. And to follow Appellee's argument to its logical conclusion, which is essentially that we're a state actor because we can enforce our covenants and we can use the courts to do that. Any property or homeowners association that assesses fines and then uses the court to collect those assessments or fines is now a state actor. There's no legal authority for that.
Shelley versus Kramer was what they were arguing, if I'm not mistaken, correct?
Yes, Your Honor, and our brief...
It wasn't the state action there, the court. It wasn't the person trying to enforce.
The state action in Shelley versus Kramer might have been the court, but it had to do with a completely different scheme. And there is, as you alluded to, there is no public use here. We're talking about private property ownership rights, a private subdivision. There's no public use. And there's no state statute or rule that favors the ability of any property owner to rent their property as a vacation home. So there's no positive law. The short-term rental restrictions don't conflict with any positive law that would support a right to engage in short-term rentals. Again, we ask that the court reverse and remand the judgment. Thank you.
Before break, I am going to ask both sides to brief that issue. I gave the cited name. Look at that.
Yes, Your
And
Honor.
look at our decisions in Disco, Machine of Liberal, Kansas, Christian versus Reader, along those lines. And let me know, let the court know
Yes, Your Honor.
if that order adjudicates anything. And if it doesn't adjudicate anything, what's the effect of Mother Hubbard language? And I'd like that, ask that you provide to us by 5 o'clock next Monday,
Monday's a holiday.
next Tuesday. That would be, what, the 16th. And with that, the case is submitted. You are free to go, and we will be in recess until our next session. Thank you very much.